I just start by thanking Dean and Policy Exchange for hosting us today, and to thank Ian, who is going to chair our panel, and above all Linklaters and Richard for this excellent report. Thank you all also for coming to talk about what can be an esoteric issue, but also something I think of huge strategic importance for the country. I think this report is a hugely valuable contribution to that debate. I really welcome it, and also it demonstrates from my point of view all the hard work that is going into preparing for Brexit amongst the legal profession. I should probably disclose my interest at the outset, which is that I trained as a trainee and then qualified as a solicitor at Linklaters way back when, in the 90s. It feels a bit cheeky being invited along to judge their homework today, so I shall resist from doing too much of that. Linklaters certainly knocked me into shape after law school, and I'm hugely grateful for the training and the mentoring that I received back then. And I should also again confess, as someone who campaigned for Brexit, pretty much against the tide of opinion in the city, including amongst some of the Magic Circle firms, I always stand in a certain degree of trepidation coming along to events like this, that Richard isn't sat there very quietly thinking, we really screwed up with that one. All I can say by way of mitigation is that at Linklaters we're always taught to place huge value on critical evaluation, really scrutinising the long-term best interests of our clients, and they sent me to Brussels for 6 months to work on EU matters, which is really where I got my greatest exposure in relation to Brexit. So I'm not quite saying it's all Linklaters' fault that I became a Brexiteer, but at a tender age they played an influential role, and I got a lot of formative experience in Brussels from working at Linklaters on competition law, WTO law, and then I left for the Foreign Office for 6 years. Enough said about that. With that in mind, I just want to thank Richard and Linklaters for this excellent report entitled Improving the UK's Competitiveness Post-Brexit by Enhancing the Rule of Law. And it reminded me of that great line by Thomas Edison that, and I quote, "Opportunity is missed by most people because it's dressed in overalls and looks like work." I'm in no doubt about the challenges and uncertainty inherent in Brexit for the UK at this very sensitive moment for the negotiations and our wider domestic preparations for leaving the EU. And I think the report is pretty clear-eyed about those challenges. But it was important to see the report also at this crossroads in our history, look in the detail and see and grasp the unique opportunities to reinforce the rule of law, to increase predictability of our laws. And there's some good stuff in the importance of predictability, and the stuff around improving the lawmaking process, ultimately with the overarching goal of sharpening and strengthening the UK's competitiveness. And I couldn't agree more with that thrust and that strategic set of objectives. And it will require a bit more listening on all sides of this debate, and it will require a lot of hard graft to make sure that we sensibly manage some of those challenges, which I think the report is right to point to, but also decisively grasp the opportunities that lie ahead. Above all, it will be a shared national endeavour. I think we need a bit more unity of purpose, a bit more national unity of purpose. And as the report says, we in government and Parliament will need advice and support from the business world, from the legal world, to help make a success of Brexit. Fortunately, there's no shortage of advice on that front. So what I thought I'd do today is very briefly set out what I see in government as some of those key challenges and opportunities affecting the legal sector. And then we'll open up the debate, and Ian will manage it, to the very high calibre panel that Linklaters and Dean have assembled. In terms of the rule of law, perhaps the most significant and pervasive challenge I feel that we face in relation to Brexit is to avoid the potential for legal disruption and the impact that this could have on businesses and citizens right across the country, if we don't address it very carefully indeed. And the rule of law, and we bandy this around, certainly as a lawyer and a parliamentarian, we bandy the term rule of law around. It's a rather grandiose term, but protecting legal certainty means making sure people have predictable rules. And the reason we want people to have predictable rules is that's what you plan your life around. And if you think about it from rules of protecting consumers when they buy goods in the shops, to the principles underpinning competition law, which I trained in way back when at Linklaters, designed to set the level playing field for free markets so that businesses can rely on them. Those are the kinds of things in our daily lives that the rule of law is really all about, providing predictable rules that people can plan their lives around. Now, I'm currently one of the ministers on the EU withdrawal bill at committee stage. We're 5 days through the 8-day gauntlet of committee stage. We've won all the votes with double-digit majority, so we're making good progress. The bill itself is pretty technical and complex, and I won't bore you with Schedule 7 or any of the detail right down in the weeds, but suffice to say, it addresses the fundamental challenge by taking a snapshot of EU law, the substantive principles, the rules, the legislation passed in Brussels, and it applies that applies in the UK at the date of departure, and it then retains that body of law as UK law. That means that we then have the time to carefully consider which aspects of EU law in the future we wish to retain, amend, or repeal. Crucially, particularly for those I think nervous about Brexit on the legal side or more generally, it averts the cliff edge, the legal cliff edge that some fear, and it paves the way for a smooth legal transition. And whichever way people feel about Brexit, I think that's something that is a shared goal. Now, in terms of the bill, clearly there are contentious issues. The government is in listening mode. I'll be in listening mode today. And that's not just sort of some rhetorical doffing of the cap in the direction of critics. We are actively making sure that we can give Parliament and the public the reassurance they need. For example, it's quite right to have a sensible debate and to look very carefully at the volume of legislation that should be passed on the one hand by primary legislation, on the other hand by secondary legislation, and there's different techniques and procedures you can use for each one of those. We want maximum scrutiny and maximum transparency, but we're also, and this is something that has to be borne in mind, we're up against a deadline. The deadline is not of our choosing, it's imposed on us under Article 50 by the EU, which is the 2-year deadline from triggering Article 50. So I guess the job for someone like me is to make sure that we can deliver that smooth transition that we all want within the time frame that we face. I'm confident we can get that balance right with the appropriate scrutiny arrangements, particularly for secondary legislation. And contrary to what you hear, I guess, in the media, with all the din that you pick up in the papers or on some broadcasters that are not as scrupulous as Sky, there is a lot of goodwill and there's quite a lot of sensible dialogue going on between ministers, MPs, across all the different areas of Brexit. And actually, there's a lot more unity of purpose around trying to get the right fit, the right design, the proper arrangements to get the legislative job done on this bill and the subsequent primary and secondary legislation that will follow. And beyond the bill, and for all the media froth, the negotiations between the UK and the EU are making solid progress in the lead up to next week's EU Council. We are, as the Prime Minister has said, within touching distance of a deal on the status of UK expats on the continent and EU nationals here. We want to make sure we can give that reassurance as an MP to our constituents, but also to all the EU nationals that are based here. And the contours of agreement on other issues, including the approach to the outstanding financial obligations, including the approach to Northern Ireland, they're also starting to take shape. And of course, the EU has instructed their officials to start preparing for trade talks, which I think is also a positive sign. Now, clearly the legal profession have got a very real stake in all of this, especially amongst practitioners who are focused on advising on financial services. I'm not going to give a running commentary on the negotiations, particularly at this sensitive moment, but we made it very clear we want a deep and special partnership with our EU friends, and that includes frictionless trade in goods and services. And I note in passing that confidence in the city remains very strong. We had, just as one illustration of the evidence for that sort of bold assertion, you've got the latest publication of the Global Financial Centres Index, which was published in September by Zedian, which ranks all the global financial hubs. London is still ranked globally #1. And actually the gap between #1 and #2, which is New York, has expanded a degree. Incidentally, there's no EU hub in the top 10. But notwithstanding all of that, we are ambitious and we're focused on getting a win-win deal with our EU partners, and there's a lot of hard work going in to achieve that. Clearly, we're going to be ready for all outcomes, all eventualities from the negotiations. It takes two to tango, but I note that on the EU side, they are also acutely conscious of the sheer volume of UK finance that goes into supporting the continental economy. Michel Barnier has actually talked quite a lot about that himself. Beyond lawyers working on financial services, in August, the UK government set out its position paper entitled Providing a Cross-Border Civil Judicial Cooperation Framework, which is to make sure in short term that we have as much legal continuity in the arrangements for the recognition and enforcement of judgments, insolvency jurisdiction and rules, small claims judgments, and family law judgments as well. And that's important if you think about it in real terms for supply chains, business transactions, but also family relationships. All those things cross borders, all those things have resonance for people, citizens, firms in their daily lives. Now, that's our aim for a deal on the civil judicial cooperation. There is a wider corpus of private international law, which the lawyers at Linklaters rely on it quite a bit, which the UK can fall back on if it's necessary. But we want the optimum result. We want the ambitious win-win scenario of a deal with the EU that allows us to continue the close and comprehensive cross-border civil and judicial cooperation, from child custody arrangements to cross-border commercial claims, that is manifestly in both sides' interests. And I think there's recognition of that on the EU side as well as on the UK side. So yes, there are challenges that we need to mitigate and prepare for, but there are also even greater opportunities. And I think it's vital that we are pretty decisive about seizing them, and as clear-eyed and clear-sighted as we are about the challenges, also clear-eyed and clear-sighted about those opportunities. I certainly agree with Linklaters and the report that we face a unique opportunity to reinforce the rule of law. The EU withdrawal bill will help guarantee a smooth and orderly Brexit, but it also delivers, let's not forget this, on the number one reason people voted in the referendum to leave the EU, which is to take back democratic control over our laws, so that MPs like me are more accountable to voters for the decisions we make and for the legislation we pass. That's part of the social contract in this country. It's not some technical procedural thing. It's absolutely fundamental to our democracy. The Linklaters report also has some good ideas, some interesting thoughts about improving scrutiny and the quality of legislation. I've certainly, as a minister, seen a lot of that sort of area, and as a backbencher have written reports and thought about it a good deal as well. And certainly as we make our way through the legislation that needs to be passed before the date of exit of the EU, and we consider the changes we can make for the future, this should mark the moment, an opportunity, if you like, for a democratic renaissance, both in terms of politicians' ultimate accountability to the public for the laws that govern them, but also the quality of laws and the scrutiny that informs them. And in that respect, I think our approach to ending the direct jurisdiction of the European Court of Justice is not some procedural housekeeping exercise. And I'm proud that we've got a world-beating judiciary in this country. I believe both on principle and in terms of producing at a practical level better quality judgments that maximise legal predictability for the citizens of this country, that the UK Supreme Court should have the last word on the laws of the land. It should do what it says on the tin. It should be supreme in a meaningful sense. And nor do I think it would make any sense to give the Luxembourg Court the crucial role of determining future international disputes that may arise in the future between the UK and the EU after we leave. As we have made clear in another position paper that we put out over the summer on dispute resolution, we need a process for dispute resolution that commands confidence on both sides. So it would be obviously, I think, partisan and lopsided to have either the UK Supreme Court or the Court of Justice of the EU to decide those international disputes at the international level. It would also, by the way, conflict with the overwhelming global practice in dispute resolution, including the EU's own practice. So if you look at the EU's international agreements, and certainly there are none on free trade where the ECJ has compulsory jurisdiction to settle international disputes. So as our position paper sets out, drawing on the EU's practice, look at it from their point of view, but also thinking globally about the huge tapestry of global practice there is out there. A typical international dispute resolution process might involve a panel of 3 arbitrators, one appointed by the UK, one appointed by the EU, and the third chosen by the other 2. And there's a huge amount of practice in this area, so it's not beyond the wit of man to find a balanced approach to dispute settlement. And just as we take back democratic control at home, we're restless in government, and certainly for those that campaign to leave as I did, we're restless to project the United Kingdom's global reach abroad. And I think that presents major opportunities for the UK legal sector. UK legal services employ well over 300,000 people, and before I hear the inevitable rejoinder that will, on Twitter, 2/3 of those are outside of London. UK law and British courts command respect right around the world. The proof lies with the 200 law firms from abroad, from around 40 jurisdictions that are currently doing business in this country today, and the 27% of the world's legal jurisdictions that already use the English common law. And according to the 2015 International Arbitration Survey, London was the preferred location to resolve disputes. Last year, just to take 1 year, we had almost 26,000 disputes settled by ADR, Alternative Dispute Resolution, here in the UK. It's kind of ironic that for all the domestic haggling and wrangling around Brexit, we risk forgetting that internationally, Britain is the place people think of about the place they would most like to come to resolve their disputes. And it's a unique comparative advantage for us. And let's not forget, just talking about this in commercial terms, this isn't just good for business. Lawyers generated 31.5 billion pounds of revenue profit in 2016, and the taxation from that goes to fund the local school, the local GP practice. So it's got a huge social benefit as well as being important for employment and for the economy. It's a major comparative advantage for UK PLC, and I think a really important distinctive element for post-Brexit Britain's USP. And as the Courts Minister, that's one of the reasons why we're investing £1 billion in courts reform, using technology to make our courts and the wider justice system more efficient, more effective, more sensitive to victims, but also just run in a more productive way and more effective way, and simpler for the parties to use in terms of litigation. And as part of that, last month, the City of London Corporation and HMCTS announced plans for a state-of-the-art court in the Square Mile. That will hear civil cases, but will also develop our expertise in tackling fraud and cybercrime, which is obviously an increasingly resonant and salient issue for the city and for businesses. So the point I'm making is that far from looking inwards, our vision is to reinforce the UK as a global centre for business, the best place in the world to resolve disputes, the UK renowned not just for our economic competitiveness, but also for promoting the rule of law and for doing business with integrity. And as we take advantage of the ability to forge our own distinct trade agenda, aside from the EU, there are huge, far-reaching global opportunities again for expanding the export of UK legal services. Free trade negotiations are never easy, and I'm not naive or blithe about that. I worked at the Foreign Office for 6 years, and I used to negotiate international investment protection and promotion agreements. I did one with Vietnam, Mexico, one with Iran under the Khatami administration, and they could be really tough going at times. Any trade investment negotiations are. But we should embrace that challenge too, from China to South America, where we are restless and ambitious to extend our market share in legal services. And in fact, I will have to shamelessly plug the Ministry of Justice is already got a Britain is Great campaign promoting the expertise of our law firms, promoting the UK as the preeminent choice for regulating international business relationships and spreading the word that the UK is the most impartial, swift and reliable jurisdiction to come to settle your disputes. And Lord Keane, who's one of my ministerial colleagues at the MOJ, launched this campaign in Singapore in October, and we're taking that message to 168 countries around the world. And of course, the ultimate goal is liberalisation of strategic overseas markets, whether it's China, India, I'm sure our panel can think of others. And ministers are already in discussions with our counterparts in all of those places. Now, sure, all of this is going to require a huge amount of hard graft, just as Edison described. But the opportunities are enormous, and we've got to be confident and decisive in grasping them. So let's be clear-sighted about the challenges in the direction of the British people. It's the British people that have chosen to go down this route. And let's avoid those legal potholes and certainly any talk of legal cliff edges in the road that lies ahead. But as we, and I think quite responsibly, seek to minimise legal risk, please, let's not cower in the corner, afraid of our own shadow. Britain's better than that. Let's work hard, and certainly let's work together, government, politicians, business, the legal practitioners, NGOs, but let's grasp the enormous opportunities for post-Brexit Britain, for democratic renewal at home, for energetic free trade abroad, and for promoting our world-beating legal expertise from Rio to Shanghai and everywhere in between. Thank you all very much.
Thank you, Dominic. Before we participate in the panel discussion, the Minister has kindly agreed to take a couple of questions from the audience. So if there's anyone who'd like to start us off, please raise your hand. Gentleman there. And please, can you identify yourself?
Thank you. So my name is Simon Jones. I'm head of FIA and the Trade Association. When we think about the rule of law, one of the things that's very important is that the law itself is fit for purpose. You talked about grasping the opportunities presented by Brexit. One of which is to just evaluate the state of law as we find it and how we apply that to what's going on with the world around us. So two of my members are launching Bitcoin futures contracts in the next few days. Another one's just pushed the button on approving this distributed ledger technology. So we're living in a world of digitalisation of finance. And so it's now the time that the UK has a unique opportunity to have a bit of a jump start on everyone else to really get its legislation in place for the digital financial services future that we can all embrace and leave behind the analog financial services laws that we find ourselves with today.
Well, certainly in relation to Bitcoin and also other areas of tech, I think there's a really interesting question about how we apply the current competition framework, EU and UK, to those areas. I'm not going to get sucked into all of that today. It's not my area, not my portfolio. But I do think it's a really interesting question. Some of that I think is probably regulatory as much as legislative. But absolutely, as we look out and certainly look globally, and tech is a key area where is the means to be grasping some of those opportunities, we've got to make sure we've got the right domestic regulation at home. And I would say that that means having smart regulation, and yes, making sure that we got half an eye or a whole eye on what's going on in the EU, but also making sure globally we make sure that our markets and our businesses are as competitive as possible for the future.
Thank you. Thanks.
From the German Business Week. Karl was here 2 days ago, the president of the EFTA court, and he made a very strong pitch that the EFTA court could possibly take over the role of the ECJ after Brexit and provide dispute resolution when it comes to open questions like EU citizens' rights and so on. And I was just wondering if you thought that was a good solution.
I think it works for the EFTA countries and their relationship with the EU under the EEA. I think we've been very clear already, particularly when we announced our dispute settlement paper, that we're not looking for the EEA model. We'll go for a bespoke model that works and is tailored for the specific relationship that we've got with the EU and based around the contours of the future trade deal and the special partnership deal that we do.
Any more questions for the Minister? Right, well in that case I will move on to our panel discussion. I'm sure most of you will recognise our distinguished panellists, but for those of you who don't, on my far right is a gentleman who I guess if he were appearing on Sky News would be captioned as a constitutional expert, Sir Stephen Laws, the former first Parliamentary Counsel. Sitting next to him is Jasmine Whitbread, Chief Executive of London First, alongside her Richard Godden, Corporate Partner at Linklaters, and of course the Minister needs no introduction. I'm going to start by putting a rather sort of general question, but it's one to which Dominic referred in his speech, and that is, what are we actually talking about when we refer to the rule of law? And it's quite an elusive concept. Richard?
You're right, it is an elusive concept, but I think in this context it's reasonably clear. At a very high level, the rule of law is simply the principle that everybody, all people, all institutions, public and... Sorry?
Can't hear you.
Gosh, that's the first time that's ever been said of me. Is the microphone now on?
I think it's good.
Good, I'll say it again. It is an elusive concept, the concept of the rule of law, but at heart it's quite simple. It's simply the concept that everybody, all people, all organisations, public or private, are subject to the burdens and benefits of laws publicly promulgated, prospective, not retroactive, and publicly administered in the courts. But in the context of competitiveness, which is what Dominic was talking about, I think the crucial elements are two things, because there are a number of, you can subdivide that into a number of elements, and the crucial ones are these. Number one, that the law is accessible and intelligible, that it's predictable and clear, and number three, that you avoid excessive regulatory or executive discretion. Bear in mind what the Minister was talking about was fundamentally predictability. That's key, because non-predictability is risk for business. You need to eliminate that risk so far as is possible. And so that becomes then critical to have those features in your law.
And Jasmine, I guess we all have to have a stake in the rule of law as well. We all have to believe in it and trust it.
Yes, I mean, I think the fact that London is such a magnet for global corporates who are looking for regional headquarters or global headquarters, I think it's got the most number of regional headquarters in the world in the city. And I think a part of that has got to be the long-term reliability of our rule of law, which is, I would only add to, I think it's implicit in the definition that you gave, but it's not just the laws themselves, the rules, if you like, that you talked about, but it's also the process by which it is administered. And I think having set that together with all of the sort of appeals processes, etc., having that very clearly established is something that business can rely on, and that helps keep our capital and indeed our country a competitive economic powerhouse.
Stephen, anything that you violently disagree with there?
Not at all. Predictability is the essence of it, that people should be able to know what the legal consequences they will experience if when they decide to act. The thing I would add is that it's not only executive and regulatory discretion that needs to be kept to a minimum, but so should judicial discretion be kept to a minimum. And that is a point that is made in the report, that that people should be able to predict what judges will obligations they'll impose on them, and that involves not deciding under some discretion that lawmakers should have done something different. The concept of the rule of law becomes problematic, becomes elusive, when people extend it to cover the idea that every policy issue has a legal answer to which the judges can, a legal answer that the judges can find, and that's not the case.
Do you mean to say that we're all putting too much store at times in the rule of law?
No, I think we should put a lot of store in certainty and predictability. I think extending the concept to include the idea that law that is clear and certain should comply with some general standards that make it unclear and uncertain, that's the extension we should avoid.
So Dominic, you in your speech referred to this, but if the rule of law is so vital for the economic competitiveness of a country like the UK, why aren't we hearing more about it?
Well, you do. It's not quite as sexy as some of the other debates that may get broadcast on Sky News, but I think there is a lot of debate that's going on, particularly now with the legislation. I think on predictability, so obviously you can have lots of predictably bad law, so it's not the only thing that matters. You can go to North Korea and predictably know that it will be deeply authoritarian and you can't do anything, so there's no liberty. So I don't think predictability is the only thing that counts. But at moments of change, I think when you're going through quite a legally disruptive moment, and there's no doubt that we are right now, I think the predictability of the alternative path you're setting, whether it's for the average citizen trying to know how they deal with a family law dispute, let's say a custody battle that's cross-border, right the way through to a business with a supply chain, I think giving them that predictability in the rules has a magnified value, and that's, I think, what we're all talking about and all agreeing violently and vehemently about.
Can I just add something?
Please do.
Which is this. You say you don't hear much about it, but we at Linklaters do. We hear our clients talking about this a lot. Now, they don't often use the words, the rule of law. They say, well, we don't know what the law is. Or they say, well, do you mean to say that somebody has discretion to decide how the heck they want? That's how it comes out in conversations every day. We're trying to attract businesses. We don't want them saying that. We want to say, we know what it is.
Jasmine, I mean, obviously London First bangs the drum for the City of London as a global entrepreneur. I mean, is this something that's been raised that you hear an awful lot?
I think that we obviously monitor the global indices, sort of the chart which are the big global powerhouses, the capitals of the world. PwC has an annual ranking. Milken just came out with their first ranking of European cities. London's #1 again. And I think on certainly if you look at a lot of those rankings, strong institutions, and might not again be exactly the words rule of law, but implicit in those rankings will be the rule of law actually. Perhaps why it hasn't had a headline is because I think it's been taken for granted in the UK. I think that people, in a way, be careful what you wish for. I mean, things tend to become headlines when they're a problem. And this hasn't been a problem area, and it's something that the businesses relied on.
Stephen?
Yes, I mean, I don't think I have anything to add to what you said.
Very good. Okay. Well, and Jasmine, we've talked a bit about improving competitiveness post-Brexit. What sort of things do you think business can do to assist the legal profession in enhancing UK competitiveness?
Well, I think one of the things that London First is really focused on, that our legal members, professional services, more broadly financial services, but also right across the spectrum of all of our members going through to construction and hospitality, right across. People often think about the city of London, but actually London is a thriving metropolis with a very broad range of businesses. And all of our business leaders are quite clear their #1 priority as we go through this period of transition is around people, actually. London has become a great global capital because it's had access to great global talent. And so that is something that is not specifically just for the legal profession, but it's something that across the board that London First is really working to try and get some certainty around. Clearly, there's the issue that you mentioned already around giving certainty for EU citizens who are already working here, and we've been arguing for that to be given unilateral, actually to be written into our own laws, and not as part of the negotiation strategy, and forget about the ECJ, but actually in our own laws, that could be a unilateral give. Obviously, the government has felt on balance differently. We've been disappointed about that because our business members feel that this is creating an impression that London isn't continuing to be open to this global talent that has made it so great over the years. So that's something that we'll continue to focus on. Obviously, we're pretty hopeful for next week, but regardless of whether to what extent the progress is made, that is something in the negotiations. That's something actually the Prime Minister could decide on unilaterally. Well,
Dominic, I can't resist asking you as a grubby journalist. What would you say? I mean, I have it night after night on my Sky News show, business people sitting there and saying, oh, well, we're worried about being able to compete for global talent post-Brexit. I mean, how would you assuage those concerns?
Well, just on EU nationals, of course, we've wanted to get this resolved even before the formal negotiations begun, but because the EU is bound by its own internal procedures, couldn't. So we've gone and tried to get this resolved as soon as possible, and I agree. And of course, coming to predictability, I feel for all of those EU citizens and British expats abroad who want this resolved sooner rather than later. In terms of the wider global arrangements, I'm sure we're going to have sensible, flexible immigration arrangements after we leave, but crucially, particularly if we keep public confidence in our immigration rules and system, we need to have some control over the rules and the volume of immigration that comes into this country, and I don't think that that's irreconcilable with the needs and the concerns that businesses have. I note en passant, if I may, that none of the people that make this argument have ever suggested we should have applied free movement to non-EU immigration. And I remember I went up to Davos last year, and there was an interesting divergence in the audience there, because I did point out that if what you're really interested in is global talent, why would you have an arbitrary set of rules only applying to immigration and talent from one continent, which doesn't apply to all of the other people that you might want to recruit from Asia to Latin America. I say this as a Brazilian wife, so I've had my ear bent about this quite a lot. So actually what we ought to have is a level playing field, and the rules at the moment, in effect, I think if you talk to Asian and Latin American people, feel that discriminate against them. But my basic point is I'm sure we'll get flexible, sensible arrangements that allow us to have public confidence in our immigration rules, but also make sure that we're open to talent from around the world.
Richard.
I notice, whilst that's a fascinating discussion, I'm not sure my colleagues have answered your question. Because you asked, what could business do
Exactly.
to
You face
advance
these
the
businesses every day.
rule of law? And also, I'd like to look beyond the immediate problem of Brexit itself and look into the future. In the report, we identify 4 things. Clearly, business needs to support the rule of law. And that means things as basic as respecting dispute resolution processes and that kind of thing, but also recognising that government and regulators, etc., have a difficult task and respecting them. In terms, though, of more positive things, there's the question of support. We want Parliament to establish procedures whereby they can get better expert input. Where's that expert input going to come to on a lot of things? Well, it's business. And business needs to recognise that whilst there's a short-term cost associated with providing that, there's a huge long-term benefit associated with it. Of course, smaller businesses aren't going to be able to do that on their own, but there are some really good networks out there to assist it. There's the Bingham Centre Network for the Rule of Law, etc. So we think businesses should do that. It would also be jolly helpful if businesses could identify more clearly the association, the connection between their decisions, investment decisions, and the kind of factors we're talking about, because I'm not sure the public fully understands it.
Very good point. Well, Stephen, moving on, we've talked about some things that business can do to enhance UK competitiveness when it comes to the rule of law. What do you see as the political barriers to that?
Well, I think one of the political barriers to achieving the rule of law, in the sense of predictability, is a growing tendency for people to think they should do politics in the courts, or at least that is the best place to do politics. And I think in connection with Brexit, and I think this comes out of the report, there is a tendency for the courts to encourage and collaborate with that approach, which I think comes from a feeling that maybe Parliament is ineffective, that our political systems aren't working, and that there is a gap to be filled by the courts. And indeed, I think Lord Faulkner has said that one of the risks of Brexit is that the courts will feel that it leaves a power gap that they need to fill. And so the political problem is establishing confidence in our systems, because I think these ideas that Parliament doesn't work and our political system doesn't work are misguided. There's been a really good book published recently edited by Meg Russell and Daniel Gover at UCL about legislation at Westminster, which demonstrates that Parliament really does have considerable influence over legislation. The belief that Parliament is a rubber stamp is a delusion, and indeed anybody looking at Parliament at the moment, and I'm sure the Minister will agree, will not think that Parliament is uninfluential in the way legislation is prepared. So it's building the political difficulty is to build confidence so that the judges understand that there are things that are more appropriately dealt with by political accountability systems, and that they are reliable and that they don't have to leap in and fill the gap.
Dominic, what's the view from the coalface?
I agree with everything you just said. I think there is huge opportunities for the public to engage with the lawmaking process in a way that there wasn't 20 years ago, even 10 years ago, and that's partly because of technology, partly because the NGOs and the campaign groups in what we've got a very liberal society, that's a great thing, a very strong civic society, so from 38 Degrees through to lots of the other groups, pressure groups, as well as traditional lobbyists who quite properly go and make sure that their industry is being heard. Actually, there's quite a lot of, and the one reality of a minority government is that every individual MP has got disproportionately more weight than if you have a big majority. I may lament that for a moment, but I can also see why it connects the public in a much more proximate way with the process. So let's not throw the baby out of the bathwater, but nonetheless, I think all the points that were made by Sir Stephen are right. And equally, I think as we move to Brexit and we think about taking back control of our laws, we should think about the quality and the process of the lawmaking, as fusty and boring a subject as that may seem to some.
If I've understood Stephen rightly, though, you're almost implying that some people perceive, particularly maybe the judiciary, that there isn't the bandwidth in Westminster in which to enact good laws.
I think that's their perception, but I think it's a misconception. But that doesn't mean that it isn't for government and Parliament to do more to indicate that the system does work. There are respects in which they're never going to be able to demonstrate that it works, because one of the Parliament's greatest influences over government is that the government doesn't do lots of things because it doesn't want to get into trouble in Parliament to do them. And that's an influence that is totally invisible. That's one of the points made in the book I've mentioned. But there are recommendations in the report for improving the scrutiny, and I think it's clear that in relation to Brexit, the House of Commons needs to find a more transparent and detailed system for scrutinising the secondary legislation that's coming forward. Not least because if they don't do it, the House of Lords will do it. And a lot of the issues that arise are going to be policy issues that it's more appropriate should be dealt with in the House of Commons. And I gave some evidence to the exiting the European Union committee about how the scrutiny should be improved. I think it would be better if there was a Commons committee that was scrutinising the whole project of amending the law using secondary legislation. And I think they really need to set out the principles, the things, the policy issues that they think are important, because if they do, government will find itself obliged to tell them when it's doing something that gives rise to a policy issue, and then it can be considered. There is a whole volume of things that are going to be done, and a lot of them Parliament doesn't need to be interested in and won't be interested in. What's needed is a system that identifies the things that are important.
Jasmine, you were keen to jump in.
Well, I was just going to say, I mean, one of the things that I think that is useful about this report is it sort of shows, it sets out quite clearly how all the different elements need to work together with each other more. So back to the point about business, and you were saying, what can business actually do to help support the rule of law? I mean, perhaps wrongly, I mean, I think all businesses that I've come into contact with, either personally or my current role as London First, certainly do uphold and respect the rule of law. I think what you've set out quite helpfully here is going beyond just respecting the rule of law to actually support it. And to do that, there need to be opportunities. And I think you then go on to talk about some of the opportunities can be afforded by business networks and so on. I mean, I think just one example of I got slightly involved in getting our London First members to engage with more, because it seemed like a really positive initiative to get business involved, was was Oliver Letwin's Red Tape Initiative, where he was looking for in early stages. It's not lobbying, but it is talking to different, looking at different sectors, but not waiting for the lobbyists to arrive and say what they want to see for their sector, but actually saying where might it be appropriate in our hospitality sectors to sort of cut out some of the unwanted red tape that's sort of crept in, and that we can all agree actually is not helpful. So that would just be one example I would give.
Good. Well, that's something I want to explore a little later in our discussion. But Dominic, you referred in your speech to the international dimension here. Where are there countries around the world from whom we can learn?
Well, I'd sort of, you mean in relation to trade or business competitiveness?
In relation to enhancing the rule of law.
Well, I think we're widely regarded as a leader when it comes to rule of law, but I don't think we should be resting on our laurels or be somehow, lacking in open-mindedness. I think in relation to the balance of separation of powers, which Stephen's really talking about, there are interesting models in North America, amongst some of the Commonwealth countries, and also, I mean, one of the tensions that we've had that has resulted in Brexit has been the tension between the civil and the common law system. That doesn't mean that we don't learn from our European partners. So I think actually I would look right around the world. But on the separation of powers, I think we probably have more lessons to learn from other common law and Commonwealth countries, just because that goes with the grain of our current system.
Richard, you're nodding there.
Yeah, I am nodding. I think it's quite telling that one or two of the examples in the report come from New Zealand. You might think, well, you know, we taught them everything they know, but actually they've got something to teach us back as well. I think that the United States has its problems of its own, but we shouldn't be so proud that we don't look across there and ask ourselves where the appropriate lessons are.
Stephen, I know you've got some examples here from the United States on this.
Well, I have. I mean, on the separation of powers, I'm sceptical about how useful that concept is in relation to a separation between the executive and the legislature, because I think, so far as legislation is concerned, the practical position is that government and Parliament collaborate. Neither has the final say. The government can always withdraw legislation that it's introduced. The government has the initiative, but Parliament also has a veto, and they work together. So the idea of the separation of powers in relation to legislation, I think, is sometimes unhelpful. But so far as the judiciary is concerned, I think there is a lesson to learn from America, because there they have, as an article of faith, the separation of powers, and yet they have a system that judges in the courts can send reports to the Congress if they are having difficulty with the drafting of legislation. Now, I think there would be an objection here if judges were asked to report to the Parliamentary Counsel Office when they had trouble with the drafting, because it might offend the separation of powers. But there is a country where the separation of powers is an article of faith, and yet they have a system where judges can tell the Legislative Council if they think they've suggestions about drafting. It's incredibly difficult for people who deal with the technical creation of law ever to get feedback that is about the technical side of it. You get lots of technical criticism of laws, the policy of which people disagree with. You don't get much technical criticism of laws, the policy of which they do agree with. But there is a system that could be used to improve the rule of law by telling drafters what they're doing that is confusing other people.
Yes, victims always shout more loudly. Richard, what about the role of the judicial review in all of this? I mean, is it a vehicle for the imposition of the rule of law, or does it provide a vehicle for overreach by the judiciary?
We sort of touched on that. Stephen has touched on it. I suspect most of the concerns that have been expressed recently in relation to the way judicial review is operating arise from immigration cases and that kind of thing. That's where the criticism has come. Now, I'm not an expert on those things. I think, though, it's worth stating two very big principles. The first is that the accountability of the executive, of regulators, to the courts is important. It's really important that the courts are there overseeing the whole thing. But second, I pick up the point Stephen made earlier. It is equally important that the judiciary recognise that they are there to effectively apply the will of Parliament rather than to substitute the will of Parliament. That's a delicate line, but it's a crucial line.
Do you want to add anything to that?
I couldn't have put it better myself. But one thing I would say, though, and Stephen mentioned it earlier, is nudges from the judiciary to deal with issues. You know, it's a bit like apathy amongst voters. Apathy can be, politicians like me obviously want to stir up enthusiasm about politics, but apathy, you know, you can't sort of negate or negative apathy in the sense that, for example, in this context, if we're being nudged to look at something, you often have this in the House of Commons, particularly on conscience issues, that all sides look at the issue, debate it, there are vociferous and vehement views on all sides, and then ultimately they decide that they will maintain the status quo because there's not a better way of moving forward. That's not some sort of grubby decision. That is inherent in democracy, where you're trying to reconcile competing views. And sometimes in the political world, for politicians who have to be accountable to their voters, you end up saying, well, actually, we haven't found a better way of doing it.
Obviously, the less policy.
Exactly.
Well, look, we've been talking about how various parties, whether that's Parliament, the judiciary, business, the legal profession, all have a role to play in enhancing and improving the rule of law. I just wonder, each of you, who you think has the toughest role in that process.
Shall I go first?
Please do. Kick me off.
I would say that there are two tough roles. I mean, hedge my bets. Number one, despite what Stephen said, reforming working practices in Parliament is, I think, a crucial task. Just to make things more fit for purpose for the next 50, 75, however many years. And it's tough. You know, changing completely the way you run your committees, scrutinise legislation, changing those kinds of things is difficult. But that said, I think ultimately it's the government, because the government's the centre of the wheel on all of this. It's they who set the tone in relation to it, and it's they who have to initiate a lot of this. We have suggested in the report a rule of law challenge. So the red tape challenge was mentioned earlier. Other way around, 1 in 3 out policy. Those have been much welcomed. They've achieved a lot. And we'd suggest that actually we need a rule of law challenge, bringing rule of law up the agenda so that it gets higher policy profile, comes further up the list of priorities. But then the devil is in doing all the detail of that. You will see we've suggested the need for a legal database, for example. It's a specific thing, but it's ridiculous. We don't have a database that's up to date. You can't tell what the law is. If we have difficulty at Linklaters, heaven help anyone else. So that kind of thing, the enhancing parliamentary drafting capacity and that kind of thing. There's just so many things encompassed in that I think ultimately it is the government that has the most difficult task.
Stephen, you keen to?
Well, I was keen to leap in because of what was said about the legal database, because I noticed that the report does quote Lord Neuberger from May this year, in which he said there are bits of the statute law database, or legislation.gov.uk, that are 6 years out of date. I mean, I'm afraid that criticism is almost 6 years out of date. 93% of the legislation, the primary legislation on the legislation.gov.uk site is up to date.
Yeah, but hang on, for me that's a negligence claim. That's 7% that isn't.
And the rest is cross-referenced and up to date within 2 weeks of the change. They are proceeding at more or less twice the number of changes that occur, so that the whole thing will be up to date in the sense that the up-to-date legislation will be available without having to cross-refer to a note that will tell you where the change is. So, I mean, I think a lot of the criticism of the government's database on legislation is out of date. It's a database that is prepared not for lawyers. It's a database that is designed, its customer base is people who aren't lawyers, and they have worked really hard to get it done. So and have improved it enormously. There was a time when it was awful. You couldn't find anything on it. But if you use well,
perhaps we should talk offline, because I can tell you I was looking for something a few weeks ago, and it wasn't up to date. And I think we do need to talk about that because it's critical.
Well, I'll put you in touch with you.
So I can say from a business point of view, yeah, the challenge is there. Yeah. It's not with business. I mean, business has its own challenges, but I don't think this would be, this is clearly an area where, the experts need to lead the charge, and where I certainly think that business should respond to the call that you're making in terms of stepping up and playing its part. But I don't think we can possibly claim that we've got the hardest challenge on this front. Elsewhere, yes, but not on this front.
I mean, that's the voice of business on this panel. Do you worry that we have sufficient bandwidth within the system to take on all these challenges? I mean, one often hears this about the wider Brexit debate in Whitehall right now.
Well, sort of the opportunity cost, really, of the focus over the next week. Yeah, business does worry about that. I mean, there's lots of things that we should be focusing on, just to keep our capital competitive. I talk about people, but actually, we need to be building homes, we need to be upgrading our infrastructure. Some of this will need primary legislation going through. There is a concern in business about the sort of opportunity cost of this understandable focus on Brexit and national government. I mean, one way of getting around that would be to move towards more devolution and to allow city regions to get on with some of the decisions that can be made at a local level, while government quite understandably is focused on Brexit. But there are also issues around sort of getting through any kind of further legislation on devolution during this period, and there really clearly isn't any appetite from government at this point. So yeah, there is a concern about the opportunity cost.
So Dominic, what about Parliament then? We've talked about the business perspective in this and the legal perspective.
But I think there's often happens a conflation of Parliament and government, and they are interlinked in the way Stephen described. But we do also have a separation of powers, and I think backbench parliamentarians feel very differently about the process to those in government. In government, we've got this 2-year deadline. We want to make sure we've got the smooth Brexit. I think on the backbenches, your average parliamentarian wants to make sure that they're behaving responsibly, and even the ones that, you know, whatever their views may be, and there's a huge amount of technical detail going through. And look, that's the challenge of the age. There's no point, I'm not sure who's in a more difficult position. I think there are different challenges all around. But what we've probably got to do a bit more of understanding it from the other side's point of view. The minister understanding it from a parliamentarian's point of view, and also business perhaps doing the same. And also all the others, we're talking about people in this room, business community, legal practitioners, who have a very clear voice. There's lots of other people who don't feel that they have a particularly clear voice in the legislative programme, and we respond quite a lot, particularly given the prevalence of social media and the email campaigns, to some people that have got concerns in those areas, and they may not quite have worked out with any forensic precision what they're concerned about, and they're not quite sure what's going on. I think some of that comes back to uncertainty. So we've got to explain in a more transparent way what we're doing. But at the same time, ultimately, if I look at what I've got on my plate next week with committee stage of the EU withdrawal bill, in order to make sure we give effect to the referendum, take back control of our laws, do it in a way that is smooth and has legal certainty, I've got a deadline to do it, and there's no getting away from that. So in a way, when you're up against a tight deadline, you make the very best that you can. But I think listening to all sides is quite an important part of the picture. Next week, I think it was mentioned earlier, the question of the balance between secondary legislation and what procedures and how much sifting we do and how much triage. We'll address that next week, and I think the government has been in listening mode, but I will not preempt that debate now.
Okay, well that's quite an optimistic note on which to end. I'd like to bring in the audience here. Has anyone got any questions for our panellists? Gentleman there, sir. And please be so kind as to tell us who you are.
Jeremy Thomas, working with the German University System here in Britain. I would wonder what would be the implications for the rights of property subsequent to Brexit. Now I confess that I'm a historian and not a lawyer, and I hope this does not seem too naive and uninformed. But at present, so far as I understand it, the Charter of Fundamental Rights, with its provision entrenching the rights of property, has been ruled justiciable by the Court of Justice subsequent to the imbroglio over the aborted European Constitution of 2004. And indeed, in the later judgment, was ruled to be justiciable here in Britain, regardless of the first codicil of the Treaty of Lisbon, which attempted to change that situation. Would the rights of property, in the view of the panel, be in any sense prejudiced or weakened? And what could we do here in the British legal system to ensure that those rights were not prejudiced, above all passing through a time of economic uncertainty and concerns amongst foreign investors as we see?
Who fancies a stab at that one?
I'll give it a brief answer. But I just say, there's a huge. Oh, sorry, I've got this back. There's a huge amount in that, but the bottom line is rights of property were established in the United Kingdom before 1973, and I see no reason whatsoever why rights of property shouldn't be established here post Brexit. So I don't see that as being a major issue in coming years.
I entirely agree with that. The Charter of Fundamental Rights is a set of general principles put on top of a load of specific rights. The only effect of putting general principles across a load of specific rights is to confuse and make unclear what the specific rights are. So it doesn't help. If anything, it hinders. It wouldn't be entrenched, and it isn't entrenched in UK law as things stand. So it has no advantages, it has a disadvantages.
Dominic.
Yeah, I totally agree with what both our panelists have said. The triplication of human rights law does nothing, because we've already got strong protections to that of the common law and the ECHR. But the triplication, the very act of trying to triplicate human rights law in this country, adds another level of legislation and regulation, which can only lead to less certainty, which then begs the question of predictability. So I think for the average citizen thinking about where they get their property rights from, actually it will make zero difference. But if we try to directly incorporate the Charter into UK law, which, as you know, is what we've resisted doing, I think it would make the situation worse, not better.
Another question, please. Gentlemen.
Hello, Norman Qureshi of Linklaters here. In the run-up to this discussion, we ran a Twitter poll asking people following us their opinion of which segment of society could do the most to improve the rule of law. Parliament, the government, judiciary, or business. And the results were more than 1,000 votes. It came down approximately 40% Parliament, 30% government, 40% Parliament, 30% the judiciary, 20% the government, 10% business. Do the panelists believe that that weighting feels about right, or do they have any different view?
No, you more or less hinted at that, Jasmine. Go on, Richard.
Just said no. Government 20%. Don't know who those Twitter respondents were. Probably discovered they were my colleagues, but I don't agree with that.
They've lost faith in the government. I don't know.
That could be.
I'd agree with the business being right down the bottom there.
Parliament more than government. I mean, that speaks to your point about the position, the relative strengths of backbench MPs during minority governments.
Yes, I think there's maybe something in that, but ultimately I think people recognise that the people that pass the laws are the legislators and they're the MPs. But personally, I'm on the hook either way. So it's a shared effort, and quite which way the balance goes, who knows.
I'd like to challenge slightly the idea that parliamentarians are only influential when there's a minority government. I don't think that's the case. I think the influence is exercised in different ways and in relation to different things, but I think parliamentarians are always influential.
Just to be clear, I didn't say that.
No, I know.
No, that was my fault. Yeah.
That was Ian.
Why do you say that? I'm really interested you say that.
Because governments respond to what happens in Parliament, whether or not they've got a majority. They don't count on their majorities. They rely on them for their existence. Maybe there are some people you can ignore, but you can't ignore everybody. And as for reforming Parliament, I think it is necessary, as I said, to produce a more transparent system that produces more confidence. But I think too much can be expected of reforming Parliament if you think you can define a job for Parliament that it doesn't want to do, and then try and get it to reform itself to do it. Parliament is ultimately a political forum, and what Parliament will want to do is to put legislation through a political filter. And you've got to go with that grain. If you're reforming Parliament, parliamentarians will want to do the things that that satisfy the needs of their constituents. In the case of the House of Commons, that's what will determine what they will do. And saying, well, they ought to be reading legislation line by line and commenting on the drafting, it's totally unrealistic to think that that's what they would do.
Well, I'm going to challenge that. Who is going to scrutinise it if it's not Parliament? We've got thousands and thousands of pages of secondary legislation going through. If it's not Parliament, who is scrutinising it?
Well, they should. First of all, they should scrutinise it from a political point of view. Secondly, they should. One of the things that is politically important is that legislation should be effective and should work, and they should scrutinise it for that purpose. And they can effectively scrutinise it by incentivising the government that prepares most legislation to do it well. And that can be achieved just by sampling, which is what happens in practice. Parliament samples legislation, and people like me who used to draft it used to think we must get it right because we don't know where the spotlight's going to fall. So we get it right all the time because we know that if they are randomly sampling our work, the minister will not want to find himself exposed when the spotlight falls on something that's defective.
But the Counsel Society statistics suggest that the average time spent on secondary legislation is 26 minutes. That's not scrutiny.
Well, again, I think it's misleading sometimes to concentrate on the formal procedures that operate in relation to any form of legislation. I think it's a sort of fault of lawyers, really, to look for direct lines of causation between. You often hear people say, well, Parliament has no influence over legislation because they very seldom pass amendments against the government. Well, I mean, first of all, that isn't actually true. Quite a lot of amendments are passed against the government. And secondly, because a lot of things that government does, all the amendments that are moved by government, a large number of them are in response to pressure from outside. And as I've said, there's the fact government doesn't put stuff in legislation because it knows that it will go wrong in Parliament. So the fact that there are very short formal stages doesn't mean that the MPs generally don't have influence over what happens, what goes into legislation. The formal procedures are the trigger. The formal procedures are the trigger for the influence, but they're not the only way in which it's exercised.
Richard, as a corporate advisor, what about the role of the regulators, the likes of the Financial Conduct Authority and the takeover panel in the city? Do they get involved as much as perhaps they ought to in terms of scrutinising some of this stuff before it hits the statute book?
I need to declare an interest. I'm a member of the takeover panel. Take it bit by bit. Regulators are producing a huge amount of law and quasi-law today. We haven't talked much about them today, but it really is crucial that they take to heart all the things that we've been talking about. In particular, I think it's a great shame that the 1 in 3 out policy doesn't apply to regulations coming out of regulators as it does within the Whitehall machine. In terms of listening, etc., there are varying standards of appropriate consultation in advance of regulations. I hope we at the takeover panel are at the better end of that. We do have a very extensive consultation process. But there is no doubt that if you talk to our clients, in the myriad of regulators out there, we could produce a SIN list of people who do and who don't listen, and who, there are those who produce real serious consultations, and there are those that don't.
Very interesting point. I could talk to you a great deal more on that. And we've probably got room for one more question if anyone's gentleman back there.
Eric Albert from Le Monde. It's a slightly tangential question, but as you know, there's a school of thought that post-Brexit, the Singapore on Thames model will be the next model. Some more deregulation. So it's not quite questioning the rule of law, but more lax laws with the same rules of law. What's the panel's view on the Singapore on Thames model?
The Singapore on Thames model has been mooted.
I think, look,
Dominic, I really feel this is one.
Yes, I feel the pause becoming ever more pregnant. Look, I don't hear anyone talking about that here, and even those who dream of it, I think, are misunderstanding the inherent tensions in our political system and the balance of views here as to which way we'd go. I think so I don't think it's particularly credible. What I do think there is a very strong case for a smart regulation, a smarter regulation, which builds on some of the things that have been said today. And I think there is all the questions that we've had here about the quality of legislation. I don't want to revisit the post-traumatic stress disorder of the referendum campaign, but you could go and have that conversation about the way EU laws are made, and I think you'd have quite magnified arguments in relation to that. So I do think there's a case for smarter regulation and a better qualitative set of assessments of it along the way. One other point I just wanted to pick up is I think there's quite a lot of misunderstanding and just lack of information or knowledge of what an MP does when they scrutinise laws. It's not just Joe Blogg's MP picking up a bit of legislation, looking at it line by line. I think given the specialisms that go into legislation, the technical detail. That would be impossible for every one of the 650 MPs to do on every legislation. There's all sorts of committees, people take particular interest in things. I've served on 3 select committees, education, human rights, and Brexit. The Brexit committee is a good example, the Brexit Select Committee, one that has quite a lot of influence, not just on the strategy for Brexit, but on the legislation and particularly on the scrutiny arrangements. So there's a way to bridge the gap, even on the most technical stuff, so that MPs and parliamentarians do exert positive influence. And I do think, well, notwithstanding the case for improving it, that it happens. I think we could easily underestimate the effectiveness with which Parliament does scrutinise stuff, notwithstanding the case for doing even better.
Anyone else want to discuss Singapore-on-Thames?
We're not a city-state.
I quite like the idea of heavy fines for people who drop chewing gum in the paper. Well, ladies and gentlemen, it's 1:45, which was when this event was due to finish, so all it remains me to do is thank Policy Exchange for hosting us, for Linklaters for publishing this excellent report, and to our panellists, if you could put your hands together please, for Sir Stephen Laws, Jasmine, Whitbread, Richard Godden, and